Did you have a chance to read that motion I sent over that was filed on behalf of Randy Rodema?
Yep, I did.
What was your reaction to it?
I think this is the kind of motion, it's not uncommon after you receive a sentence that is less than favorable, that you're looking for all possible avenues to mitigate that sentence. And I think this is an effort to do that. I didn't necessarily see anything there that was unique to what folks every single day in our criminal justice system suffer from by being incarcerated. Incarceration is awful. Our jails, our prisons, they are not good places to be. It is punitive, but at the end of the day, I think in many circumstances, it goes above and beyond just being punitive. I did not see anything in his motion that surprised me, because it is what folks who are serving these kinds of sentences suffer from. That level of stress, anxiety, and he gets out every single day, presumably, and is only there on nights and weekends. I think, appreciate, and I hopefully folks who see this can appreciate how hard it is for folks who don't have the benefit of something like work release, where they do get out and see their coworkers and families.
So you said filing these kinds of motions, though, not unique necessarily, right?
Yeah.
What about the reasoning? So if you were to, in a hypothetical world, file a motion like this, what kind of reasons might lend itself to being a successful motion in the sense of actually getting someone a change in their sentence?
I think that for it to be a successful motion, oftentimes what you deal with in the criminal justice system are situations where there's like a mandatory minimum sentence, and the judge did not have discretion at the time of granting that sentence to give, say, for instance, a prison sentence. They either were going to give probation and no time incarcerated, or they were going to give, like a 10 or 5-year prison sentence. And, that's neither option in certain situations is ideal. You may say, just probation is too lenient, but gosh, 5-10 years prison, that's too harsh. And so oftentimes what I see on these, we used to call them 120-day reconsiderations, is this a way for a judge to get more incarceration time on a case without having to give someone probation, but also not having to give them 10 years. Someone can come back within 126 days, and it can be reconsidered to something that a judge maybe sees as more reasonable. Someone getting what is, I think, a pretty light sentence given the convictions, and some would say very reasonable, but I think certainly not unduly harsh, coming back and I think sort of advancing arguments of the hardships of jail, which are not controversial. Everyone knows jail's difficult. I have not seen those be that successful, but when you're talking about law enforcement or folks that are kind of adjacent to the system and not so much in it, I feel like nothing would surprise me.
So really we see these kinds of motions for alterations in a sentencing on maybe longer periods of time that someone could spend behind bars. Is that a safe way to?
And you don't usually see it on work release. On work release, someone is getting, and they think they even cited it, they're getting day for day credit. So for every day they're out, they're getting an extra day credit. They end up doing a less of a sentence. They're getting out every single day. They can work, I think, 12, 16-hour days in some cases. And they're really only in the jail on nights and weekends. So they're not there during the day when folks are going to court and coming back after they've just gotten some bad news from a judge. So you don't see a lot of people trying to reconsider from work release. In my experience, is folks who've been given very harsh prison sentences that are looking for consideration. And when judges grant them, they grant them sort of, I think, knowing on the front end that the prison sentence was harsh, but ultimately their hands were tied, because it's like they're either going to give a too harsh of a prison sentence or too lenient of a probation sentence. So, the message is come back in 126 days, and maybe there's something that we can do that better reflects, the nature of the offense.
This may be a hard question to answer just because of the breadth of it, but is it fairly unique or rare to see one of these motions granted by a judge?
I think so. There's not really a drawback other than it not being granted to filing these. There's, I guess, always a scenario, because I think the law is silent on it, where a judge could reconsider and impose something worse to the extent that they would have the discretion at the original sentencing. But that very rarely happens. So, what typically happens is they file these, the prosecution responds, and the prosecution in this case has yet to substantively respond. I think that will come, probably either in 21 days or more. I would guess more. And if it doesn't get granted, then it doesn't get granted, and the person is in the same situation they were in before filing the motion.
Would you be able to wager a guess at what the prosecution may say in their response?
I think I would anticipate a similar response to what what you and I are discussing here today. That I think, yes, jails and prisons and doing a jail sentence is difficult. It's not ideal. There are folks who are doing jail sentences who suffer from mental health, who suffer from stress, who suffer from anxiety. I would anticipate the prosecution would say, there are behavioral health services and treatments available that he can avail himself to. And I would anticipate the prosecution essentially saying that, look, this is unfortunate, but there's nothing really unique here that folks all over our penal system in this state and country suffer from every day.
And I'm going to ask you one more question about a guess of yours. Would you anticipate this motion being granted in this case?
I think that if this were an everyday citizen off the street, I would anticipate this would not be granted. But I think that when we end up in this sort of ballpark of, we're talking about law enforcement officers, I don't want to necessarily say that the rules are somehow different, but we are, I think, in a field or a ballpark that really anything can happen. But I think if you look at what happens every day in our courts and how many of these motions are filed regularly by folks looking for some sort of sentencing relief, this is not the type of motion I would anticipate be granted. But again, we're in kind of a different state of play.
I think we've covered most of the big points, but is there anything you feel like I am missing or something you did not get a chance to say?
I think this will be it'll be very interesting to see how this plays out, and I'm definitely going to be following it. I think this has the potential to bring to light some of the circumstances that men and women and others experience all over our penal system, in our jails, in our prisons. And hopefully what this ultimately does is enable the public to come away from this, I think, just more educated about just the harshness and the realities of doing time. And they factor that in to sort of how they live their lives. But my, I guess, sort of fear is that if this ends up being a situation where he is ultimately granted in-home detention, when I'm not really seeing anything in this motion that would warrant it, for him more so than anyone else, then now we set up this double standard and we sort of perpetuate it going forward. And I don't think that that's good for anyone.